list, and that even housing, a lot of these people need affordable housing, and the last thing you'd want is them for it to be tainted with being alleged to be a gang member and not be able to get into affordable housing. And then one last thing. How, if this bill were to become law, what would be the future of the CalGang database? Understanding that in my district, in Desert Hot Springs, just last week, there was a 9-month investigation that I'm sure had a link to the CalGang database, which netted in 30 arrests, 23 illegal guns being apprehended, 2 rocket launchers being apprehended. It's my contention that this is going to neuter your ability to get this useful information so that we can get these gang members and these weapons off the street. So if you, it's a lot to decipher, but if you can address those, I'd appreciate that.
Joel Cobb, Fresno Sheriff's Office again. Probably the best way to explain that is to understand how the system works. The individual agencies from their law enforcement contacts in the field contact the individual, make the officer in the field makes the determination whether they need to document what the individual shows. If they show any gang criteria that has been vetted out through the courts over the last 20 years, case law to support it, the individual officers document that information, they will submit it to their gang investigators. The gang investigator will then, or someone from a gang unit will look at that document, determine whether it meets CalGang criteria. If it meets CalGang criteria as spelled out in the CalGang policy and procedure, which is online through the DOJ website, it's all spelled out, the criteria and how it's all, the procedure's all done. Then the agency has the option of putting it into the CalGang system for all the other agencies to see. There's no, anybody who has access to CalGang has to go through a 16-hour course for data entry to make sure that it's all done. So they identify a number of criteria, or identify it. They have to be well-trained in the identification of 28 CFR, Part 23, confidential intelligence database, gang criteria, 186.22, and the number of subsections that spell out what a gang member actually is. I'm going to make an assumption, probably a bad part of my deal, but I'm going to make an assumption here. We do not release information out of CalGang because it's a confidential intelligence database. The information that is in CalGang came from the agencies that voluntarily put their reports in there to start with. So if someone who has been denied rights or believes they've been denied rights may have had the background done on a local agency level where those documents were obtained. For example, Fresno Sheriff's Office, we maintain our gang documents, field interview cards, gang reports that have gang indicia in them, gang reports that there was actual gang crime involved in our local records management system. From that point, it's determined by our staff, our investigators, whether that information can be put into CalGang or not. All CalGang is a pointer system to where those documents are actually held. That's it. As far as statistical information, we've never been asked by anybody to provide it. We'll provide whatever you need statistical-wise. We have no objection to that at all. There's never been an attempt to hide anything. We just can't release anything out of CalGang that identifies a specific group of individuals or a specific individual because of the 28 CFR compliance.
Okay. Thank you, Mr. Cobb. Senator Stone, did you get your questions answered?
I think so. The last question I don't think was answered is if this were to become law and you had to send letters and appeal processes, how do you see that affecting your list and the fiscal aspects? It seems like it'd be a very costly endeavor.
That would be the end of CalGang.
It'd be the end of it.
Yes, it would.
That's pretty.
It won't exist.
Pretty moving. Thank you.
Can I respond to that, sir?
Ms. McGill, very briefly, we have another question.
We were sponsors on the original bill that looked at CalGang, Senate Bill 458. These same concerns were raised then. It didn't lead to the end of CalGang. In fact, what it did is led to the improvement of CalGang. Just asking for some transparency and some oversight meant that between the passing of that bill and it became law in 2013 and the current date, the list statewide was at 202,000 and went down to 150,000. And even law enforcement has told us that the criteria is so broad that the cleaning up of both the local shared databases as well as the statewide databases benefits them. We believe that transparency is also good for law enforcement. Similarly, we did put in a Public Record Act request at that time, and we went directly to the Department of Justice, and it wasn't easy to get the information. So the idea that this information is easily released is not true. In fact, currently there's an audit of CalGang, and even there, it's been a very robust audit, so I think that will also illuminate that issue also. Finally, I want to just point out what both the testifiers as well as Assemblywoman Weber have already said, that there's already in the bill a very strong section that says that if you're a part of an ongoing criminal investigation, you do not have to be notified. So it protects all of the investigations similar to the one that Senator Stone mentioned from his district.
Thank you, Ms. McGill. Senator Glazer.
Thank you, Mr. Chair. My questions are to the organizers of CalGang. So could you tell me what the proportion is of those in that database are juveniles or adults?
Less than 2% are juveniles. The downturn from that this young lady mentions from over 200,000 2.5 years ago when SB 458 took effect to around 150,000 now has nothing to do with juvenile notification. In fact, we don't notify juveniles that they're in the database. That's not required in SB 458. What's required in SB 458 is when they're designated. Releasing information from the CalGang database back to the juvenile or his family is a violation of federal statute.
Right, okay, so you're saying 2% of
2%.
Your database
So, and that
are juveniles.
of those 50,000 that were purged, perhaps 2% of those were juveniles. The records that were purged at 2 o'clock this morning automatically were put in the system 5 years ago.
Are you prepared to talk about then the effect of the Wright bill in 2013 on this designation and what that did to including or not including juveniles?
2% is a statistical nil. It made no changes to the database. Yes, we're notifying juveniles when they are designated.
That's based on those that are in the database, and you said that the effect of that legislation was in designating individuals that may be put into the database.
I'm sorry, but
Right, you I think correctly identified the Wright bill as notifying a minor or his or her parent or guardian before designating that minor as a gang member, right?
at designation.
Right, so it's not about what's in the database?
It's when they're designated
Right,
before they go into the database.
which would be similar to what would be in effect in this proposed legislation, is that right?
Yes, but no other criminal intelligence database notifies narcotics offenders.
Oh, hold on, let me just ask my question though, just to be clear on this. So do you know what the effect of that law was in this designation category has been, and what's happened after that law was enacted 3 years ago?
We continue to designate juveniles. We notify their parents. The juvenile and their parents or guardians, they're allowed to request an administrative hearing. Los Angeles Police Department, Los Angeles Sheriff's Department presented statistics of several hundred juvenile designations that have been made. Less than a handful have ever returned the phone call.
Okay, so what you're saying is that under the Wright legislation passed in 2013, there have been hundreds of individuals juveniles that have been designated, but only a few cases that you're familiar with where that's resulted in appeal of that designation.
That's correct.
So what I'm having trouble with is the assertion that this is a big disaster, this legislation, that this is going to, according to the Sonoma County Sheriff's Office letter, eliminate a successful and proactive investigative tour, eliminate, when as it relates to juveniles, at least you've indicated that there's been, seems like very little effect.
Well, the truth that the juvenile justice system attempts to rehabilitate. There's no rehabilitation in the adult system. And that's the reason that the operators of the CalGang system agree with Senator Wright, at least on that matter. We agree with Senator Wright that juveniles and their parents should be notified because they should be afforded the chance to.
I appreciate that, and I don't disagree with that view of minors and what we hope to accomplish with any kind of rehabilitative or conversation about where bad activities may lead to worse activity. But I'm going back to my question, which is that there's an assertion that this legislation would eliminate, and that's the word that's used in the letter from the Sonoma County Sheriff's Office, this tool, eliminate, that by communicating with someone who's been designated, you're going to eliminate this tool, and that's where I'm struggling.
So Dr. Weber's bill, currently 28 CFR 23, the federal statute, allows designation based on a reasonable suspicion of a trained law enforcement officer. Reasonable suspicion is, granted, a very low burden of proof.
Right.
Reasonable suspicion. Dr. Weber's bill will allow us to only keep intelligence information on individuals that have been convicted of a violation of 186.22, and then only for 3 years. The federal statute allows 5 years based on reasonable suspicion. Dr. Weber's bill is 3 years based on.
Right, now you're talking about a different element of the bill, and we can get to that in a minute. But I'm dealing with the element that you have to notify them when they've been designated, and you feel that that's going to substantially undercut your ability here. And yet you don't see that with juveniles, so I'm trying to have you answer that question directly as to why you think
juveniles are a very small percentage of the data.
I understand that point, but you pull me over, you have reasonable suspicion, okay? You designate me now as an adult to be on the list. Now, under this legislation, you're required to notify me of that, right?
This legislation would require that, yeah.
Okay, so.
However,
yeah,
I could only keep that information if you've been convicted.
I got that. That's a separate part of the bill, and we can deal with that. But I want to understand why you think this designation and this communication erodes your ability to catch bad guys, which we all want to do.
It's the totality of the bill.
Okay, but so at least you're not giving me an answer. I appreciate that. You have other issues with the bill, but at least as it relates to designation, you don't seem to be giving a defense for why this is going to create havoc in law enforcement and tracking down gang members.
It's an unusual precedent to to notify somebody that they're under investigation before.
Okay, but I would suggest to you that you pull somebody over and you take their information. I think that they've gotten some indication that you might just be on their list for a while. Okay?
They should know.
Fair enough. And I think some people might suggest that the notification might have the opposite effect of letting somebody know that they need to straighten up, that maybe they were thinking about moving into a gray area of our society, that's maybe not the nice, good thing to do. Some might suggest that. Let me ask another question. There's been some statistics offered up about race. And I wanted to, and they're pretty stunning. I wanted to give you the opportunity to address that in terms of whether, what that might suggest to you about the fairness of this, this database.
And I'm not going to apologize for statistics. Statistics are.
Did you dispute them?
Excuse me?
You dispute the numbers?
I do not dispute the numbers. In fact, I personally gave the Youth Justice Coalition those statistics.
Thank you for doing that.
Thank you. You're very welcome. The only thing that's secret in Cal Gang.
In the pursuit of truth and justice, that's a good thing to do. All right. And finally, let me address a question that typically would be looked at our fiscal committee, but there's an assertion that there's a big cost factor in relationship to this bill. When you put somebody in the database, do you have an address affiliated with that individual in the database, or that's not always the case?
I'm sorry, what was?
An address, a location where they live.
That's usually supplied by them if.
But would you say in the database that you have, what percentage of them do you have addresses for?
Probably the vast majority.
Okay, because there is an assertion here that there's a great administrative cost to this notification.
The administrative cost is the appeal process.
But we indicated as it related to juveniles, there were very few of those appeals.
That's true.
Okay, all right, thank you, Mr. Chairman.
Thank you, Senator Glazer. I just wanted to give you a chance to correct a statement that I thought I heard you said, which was there is no rehabilitation in our adult system.
The goal of the adult system is more punitive than rehabilitative, whereas the juvenile system isn't entirely rehabilitative.
We amended the preamble to the California Penal Code a few years ago to change that, and we added rehabilitation to the title. corrections and rehabilitation.
And I understand that.
Yeah.
However, the criminal justice, the adult criminal justice system has very many differences from the juvenile criminal justice system.
That I will not argue with you. But to hear a law enforcement officer say that there is no rehabilitation in our adult correctional system disturbs me greatly and gives me a sense of how you approach our criminal justice system.
And then I didn't mean to mislead you, sir.
Okay, that's why I gave you the chance to correct it. Thank you.
Very good.
I know we have a long agenda, but this has been a very important discussion. Senator, did you have a question?
I don't have a question.
Okay. Go ahead.
Oh, okay. I don't have a question, but would you like?
You can make the motion, and
I'll make the
we'll
motion to
take care
bring
of
your
it.
bill.
So we do have a motion. We seem to have exhausted questions, comments from the committee. Assemblywoman, I want to thank you for bringing this forward. I think, though the scope of the bill may appear to many to be somewhat narrow and only impacts certain communities and not other communities, and I think that would do the bill disjustice because it has broad implications. I'd like to be added, if you're amending the bill, as a co-author for the following reason. I think it's a very important bill because of the gang-related penalties that are affixed to sentencing, from 6 years to 15 years to life. These are major changes. And we've had this conversation in this committee and throughout the legislature for the past number of years, that to the degree that we put more and more people behind bars for longer and longer periods of time, we impact families, we impact communities. There's a generational cycle of incarceration. It costs us more money. We get worse results. We have higher rates of recidivism because we're not investing and focusing more on rehabilitation, which is, I thought, been a significant policy direction that this legislature and state, along with its former governor and current governor, have taken in recent years. So this has broad implications and broad ramifications. And the idea that a young person or any person, young adult or otherwise, who's not gang-related could be on the list, arrested for a crime he or she did not commit, be convicted, and have enhanced penalties, innocent all along the way, and have very little recourse to at least deal with the enhancements. But we know that we are wrongly incarcerating people. The numbers continue to grow. And so I think you're onto something very important here. And I know it is difficult, and I respect the good folks who do the difficult and dangerous work every day to keep our communities safe. But I know there's always resistance to any kind of change. We're all like that. We're all human beings, and change is difficult. But I think if you were trying to eliminate the list, that'd be one thing. You're hardly trying to do that, and the provision that you have that if there's an ongoing investigation, this will not apply. I think you've got some real safeguard measures in there. So I will be supporting the bill today, and we can call the roll. Oh, would you like to close? I'm sorry.
Just simply to thank those here from law enforcement. It seems like every law enforcement agency in the world is here, so I don't know who's guarding the streets, but nonetheless, and I do want you to be there to guard the streets. And like I said, this is not it should never be interpreted as this is a bill that's soft on crime. It's a bill that really gives support to gang activity and those kinds of things. No one has fought gang activity more than I have in Southeast San Diego and in the state of California, because I understand the impact it has on people's lives for a very long period of time. And I know it's really hard, those of us who work to get kids out of gangs, to get them out of gangs because of all the things that are surrounding it. But I also know the devastating impact it has on a person's life to believe they're on a list that they have no ability to get off. They don't know if they're on or not on, and the kind of atmosphere it creates in a community. And no, you don't have to be under investigation to be on the list. They kept saying you have to be under investigation. You don't. You don't have to be under investigation. If you look at the criteria, they're so loose. You could live in a community, be talking to people, they can take pictures of you, or as my son was simply driving through the gas lamp and was pulled over and threatened to be placed on the list. That happens in our community all the time. And so as a result, there's a need for transparency to really restore the confidence of the community in relationship to gang activities and the persons who live, who basically are the officers in our community. This is a modest bill about transparency. Notifying a person before you put them on the list that they're going to be put on the list. As you pointed out, some of them won't even appeal it because maybe they are gang members. But those who aren't should have the right to appeal and not have themselves placed on a list that does have some devastating effects on people's lives, especially since we have decided in California that being a gang member will automatically get you certain additional time in jail and so forth and so on. And if you don't know you're on the list and you end up being on the list and even if you commit the crime, do you deserve the enhancements? Those kinds of things are important. So for fairness and transparency, I respectfully ask for your aye vote, and I appreciate those who've come here today to testify for, as well as those to share information against the bill.
Thank you, Assemblywoman Weber, and we have a comment from Senator Glazer.
Thank you, Mr. Chair. Before the close, I didn't get, all right. Before the close, I didn't get a chance to follow up, and I appreciate the opportunity. And I want to thank the Assemblywoman for her thoughtful proposal that's before us. And for me, and I know for all of us, this is a challenge of balancing a lot of different issues. We certainly want our communities to be safe and want people who engage in inappropriate gang behavior to be identified and prosecuted. And I think that part of the element of this bill that we haven't really spent much time talking about is this 3 years, where they get bumped off after 3 years, and maybe because of time, we don't have the chance to pursue that further. But I think because of how the opposition has presented their view, I think it may be a shortchanged that conversation, which may be valuable still to have. But I think this bill does try to strive for that balance. And I don't think that designating someone and letting them know is necessarily going to impede law enforcement and their ability to keep our communities safe, and they have a tough job to do. And so for those reasons, I'm going to support the bill today. And I do hope that further conversations can take place about this issue. Is 3 years right, or should it be shorter or longer? I don't think we gave that the time it needed today, but I hope that you'll continue to consider that.
We'll continue. We're actually talking with individuals now about the 3-year issue and whether or not it's an automatic purge or an opportunity for appeal. Those kinds of things may exist, but there has to be a process that allows you to get off the list. There has to be a time frame that we say you can get off the list if you actually remain on the list, given the criteria, if you meet some of the criteria. There ought to be some reward if you've been a good citizen for 3 to 5 years. There should be some reward that comes along that says, okay, you're no longer on this list, you're no longer designated. And doesn't mean that you can't be put back on the list either. Well, that's extremely important.
You've got your votes.
Okay, thank you. Appreciate it.
Thank you. We will call the roll.
Hancock, Anderson, Glazer. Glazer, aye. Leno. Aye. Leno, aye. Liu. Liu, aye. Monning. Stone. No. Stone, no.
We'll place that call
Thank you very much.
on call. Thank you, Assemblywoman. Thanks all who contributed today to the conversation. Assemblywoman Campos, you are right. You are next. I don't know about that. We have our item 24, your bill AB 2199.
Thank you, Mr. Chair and members of the committee. First, I want to accept the committee's amendments and thank the committee for working with my office and making the bill much stronger.
I just want to make sure the entire committee has copies of the amendments. Is that correct?
I'll go ahead and read them. These amendments will remove employee from our definition of position of authority, as well as change the definition of undue influence to address the committee's concerns.
Assemblywoman? Excuse us, just one moment.
Yes.
Assemblywoman, just to be clear, there was some confusion. Could you read what you believe the amendment to be?
Okay, what I believe the amendment to be will remove employee from our definition of position of authority.
That's a different technical amendment. Then there is an amendment that strikes the definition of undue influence currently in the bill, cross-reference to the Welfare and Institutions Code section on financial abuse of the elderly.
Correct.
All right. And so the definition of undue influence would include, but it's not limited to, the use of affection, intimidation, coercion, deceit, or taking, withholding, or bestowing a reward or benefit, or promises or threats to take, withhold, or bestow benefit or reward.
Correct.
Great. So we're on the same page.
Thank you.
Great. Please proceed.
Thank you. Our criminal justice system has come under tremendous scrutiny. Just recently, out of Santa Clara County, we were all horrified to learn about the ruling in the Brock Turner case, in which a Stanford student who raped an unconscious woman behind a dumpster was sentenced a mere 6 months in county jail. Members, that case brought national attention to how rape culture is perpetrated and the way society attempts to excuse sexual assault. When I started this journey on this particular bill, that case hadn't happened. And this is not the first time that myself and other women and other members have brought an issue similar to a committee. So today, members, I come to you with a bill that looks to start the process of addressing our injustice culture by giving tougher sentences to adults who prey on children. AB 2199 would provide district attorneys an optional sentence enhancement of 2 years if an adult holds a position of authority over a 14 or 15-year-old minor and is found guilty of a felony of sex offense. When a person leverages their position of authority to groom, exploit, and have sexual relationships with a child, they should receive a harsher sentence than someone who steals a car or writes bad checks. It is time for us, as a governing body, to say and start moving towards sentences that will not tolerate rape in the state of California. I have witnesses with me today. They will testify on the importance of this bill.
Thank you, Assemblywoman. In support.
Mr. Chair, members, my name is Morgan Geyer. I'm a Deputy District Attorney for Sacramento County. I've been a prosecutor for nearly 17 years and have spent nearly half that time prosecuting sex crimes against children, and prosecuted hundreds of sexual assault cases involving victims of all ages and developmental levels. While AB 2199 adds an enhancement to an arguably already burdened penal code, to the extent it adds a few people to the prison population or extends the sentence of someone already headed to prison, those individuals are a deserving few. In Sacramento County, we see these position of authority offenses on this age group fewer than 4 times a year. But when they occur, their effects are devastating to the victims left to cope with the shame, guilt, and humiliation, and the community affected by the offender, which is left untrusting, suspicious, and skeptical of those devoted to working with and helping our children. The bill adds the enhancement to conform the exploitation of a 14 or 15-year-old to a level of relative consistency among other sex offenses. For example, a 51-year-old coach in Sacramento County induced a 14-year-old player to perform an act of oral copulation. A 28-year-old group counselor sodomized a 15-year-old in a children's receiving group home. And a 34-year-old female teacher orally copulated a 15-year-old student. The offenses covered by this bill deal with victims who were induced. They were convinced, persuaded, enticed, influenced. They were preyed upon for their lack of world experience and youthful judgment. And for that, they bear the enormous burden of guilt and shame. This enhancement does not apply to forcible sex crimes, crimes in which the victims had no choice and for which the penalties are already severe. AB 2199 represents a particularly vulnerable age group, 14 and 15-year-olds, experiencing a greater degree of freedom and involvement in activities with less supervision. an age group completely immersed in technology and social media, the unfortunate breeding ground of opportunity to groom and foster inappropriate sexual relationships, often undetected by parents. 14 and 15 years of age is tough, even when everything goes well. But for the victims that have to bear the guilt and responsibility for these crimes, it takes a toll that is difficult at best to overcome, and oftentimes lead to devastating results like depression, withdrawal, and tragically even worse. This enhancement recognizes and assigns responsibility to those who would violate the trust we place in people charged with protecting, teaching, and guiding our teenagers. For these reasons, I would respectfully request an aye vote. Thank you.
Thank you, Mr. Geyer. Others in support?
Thank you, Mr. Chair and members. Dawn Kepke with McHugh Kepke & Associates on behalf of Crime Victims United of California, and very strong support. In recent years, Crime Victims United, working statewide on behalf of and with victims, has received an increasing number of calls regarding these types of cases, and which, really bring home the fact that these young minors are impressionable. They're already struggling with relationships, feelings, friendships. It's a very impressionable age, and so to have adults in these positions of authority who seek to prey upon these minors is really concerning, and is certainly something that Crime Victims United would like to work to elevate the accountability for those situations to hopefully deter. So for these reasons, we're very strongly supportive and really urge your aye vote. Thank you.
Thank you, Ms. Kepke. Others in support of Assemblywoman Campos's bill?
Good morning, Mr. Chair and members. Sean Hoffman with the California District Attorneys Association in support.
Thank you, Mr. Hoffman.
Good morning. I'm Don Hoffman with the Los Angeles County District Attorney's Office. We support the bill.
Thank you, Mr. Hoffman.
Jeremy Hinkson with the California Civil Liberties Advocacy. We support this bill.
Thank you, sir. Anyone else in support? Anyone here to oppose? Please step forward. As we welcome you, I just want to make sure you had a copy of the amendments. Familiar with them?
I don't know if I...
Okay.
I'll give it to you.
Just so we make sure we're all talking about the same bill.
Back and forth between...
No, it's a busy day for all of us, I know.
Yeah.
So just tightening some of the language.
Right. Yes, thank you.
Okay.
Good morning, Micah Doctoroff on behalf of the ACLU of California, here in respectful opposition to AB 2199. While we understand that AB 2199 appears to provide greater protections for minors, and without discounting this incredibly important goal, we do not believe that creating a new sentencing enhancement will accomplish that goal. Research has shown that more severe sentences do not actually enhance public safety. Rather, researchers have found that the certainty of punishment that someone will be punished for a particular crime has a greater deterrent effect than the severity of the punishment itself. California law already provides significant punishments for the underlying crimes listed in AB 2199, not to mention the myriad of existing sentencing enhancements. For now is not the time for California to be adding longer prison sentences to crimes, particularly when it is not clear that these longer sentences will have any greater deterrent effect. For these reasons, we respectfully oppose the bill. Thank you.
Thank you. Anyone else who'd like to speak in opposition to the Assemblywoman's bill? Senator Stone, you have a comment or question?
A comment, Mr. Chairman.
Please proceed.
Thank you very much. I'd like to applaud Assemblywoman Campos for bringing this forward. I think anyone with positions of authority have undue influence over our youth that, as mentioned, are inexperienced and extremely vulnerable to social media. And while the ACLU says that increasing the term of their time in jail will not enhance public safety, I do believe in enhancing the punishment for those that take advantage of our kids that leave scars on them for the rest of their lives. And for those reasons, I'm going to move your bill.
Thank you.
Thank you, Senator Stone. We do have a motion. No other questions from the committee. Assemblywoman, I'll be supporting the bill today. I have some of the same concerns of the ACLU as to whether sentence enhancements actually deter bad behavior. But because of the nature of what you're addressing here and the seriousness of it, I will be supporting the bill. And just to credit the ACLU, you are always consistent on the subject of sentence enhancements. So That's an important thing. I value consistency. So we have a motion by Senator Liu.
Stone.
Oh, I'm sorry, Senator Stone. That is correct. And we will call the roll. Oh, would you like to close? I'm
I
sorry.
respectfully ask for your aye vote.
Thank you. So this is as amended.
Yes, as amended.
Hancock, Anderson, Glazer, Glazer, aye. Leno,
Aye.
Leno, aye. Lou, Lou, aye. Monning, Monning, aye. Stone, Stone, aye.
Assemblywoman, we will place that bill on call.
Thank you.
Thank you. One little bit of housekeeping for those who are interested. AB 2083 by Assembly Member Chu is pulled and will be reset for next week. And our next author is Assemblymember Linden, who had been here. Not sure if that is still the case.
Number was the one that's been, what item?